Before today.
Yes.
Your education, high school, college.
Masters.
And you can like the English language, correct?
Yes.
You carry along.
How many years? Yes.
that, actually, the language of that, so that, if it, and as long as it comports with what we discussed, which I think that's exactly what we were talking about, and there should be no issue.
Okay.
And if you would like me to, what, we agreed to waive grand jury, we signed that on Friday. And it essentially, of course, it reviewed it, you know, the, county accused. But the to wit essentially is defendant did maliciously cause Logan Waller, a child under the age of 18, cruel and excessive mental pain by touching a part of his body in an insulting and provoking manner. That's cruelty to child in the first degree.
All right. But that's, so is it one count?
One,
One count of cruelty to children in the first degree.
correct.
All right. Nope, not yet. I've got what the reaccusation looks like. Yes. And it really should just be 24 SC 005-809-02. But I think the clerk's office has to confirm that.
They haven't answered mine.
Okay.
My message that the new APA is supposed to start.
Yeah.
Okay.
Yeah, but she's stuck in traffic. You need to leave work earlier when we have court.
I was curious when I looked up her name. Did you do the same?
Not yet. You find anything?
She just passed the bar in August.
Oh, that I learned when I met with two of the tip-top supervisors. And I said, so tell me about her background. Like, oh, non-complex. Okay, but before that, she passed the bar. I said, oh. Oh. An unmolded mind, a blank canvas.
We'll continue to run through the training.
Yeah, that's what they said.
Ms. Fry,
Yes.
you think we should, well, yes, Judge. Your Honor, should I just go ahead and forward the, conditions to Ms. Nelson or to you? They are rather lengthy.
You don't need to, well, yeah, why don't you forward them to both of us?
Okay.
I jot them down. It's Ms. Nelson who needs to make sure they get into the final disposition. So why don't you copy Ms. Fry on it just so she can be looking at it and say, wait a minute, we didn't agree to this, or it was 7, not 9, or whatever is in there. But Ms. Nelson would be very appreciative if that went to her, and it helps me to see it.
Ms. Fry, I'll just copy and paste.
Perfect. And what we just, what's the email? Right?
Yes, what, Mr. Denslow sent.
Yes.
Your Honor, Ms. Fry, it looks like I finally did it correctly. We have a new case number. It is not -02.
Okay, it is?
25 SC 006573. And one of the deputy directors in the clerk's office, emphasized that Mr. Gentle, must be sure to take the plea on the file stamped accusation.
I'm not quite sure what that means, but I'm pretty comfortable that we can go forward. I'm gonna just get that up on the screen here.
And the stable for your non-house brokers.
We'll get all that on the record. There it is. All right, well, I think we're good to go. Ms. Williams, are you waiting on anyone else?
We had sent the link to the victim and his family, and literally sent a text message.
Okay. We didn't have a link till kind of this morning, so I don't know what you sent.
Okay, so can I forward, would it be all right if I forwarded that link to them now?
Yeah, you should have it. I got it at 9:02 this morning from Ms. Nelson, and you were copied on that.
Okay.
So if you want to forward that. And Ms. Fry, do you have everyone you need here?
Yes.
Okay. You release Mr. Denslow for the day?
No, Judge, we have another client we're trying to get out of jail. We've got lawyers all over the place.
All right.
3 different counties.
Ms. Williams, can you pop the camera up out of
Oh, yes.
that screen? Ms. Nix loves to hide it.
Well, these internet cameras are not the most flattering, so I have to.
I don't know how many are currently pointed at me. They say the camera has 10 pounds, so I must have at least.
So just stand it. Oh,
Okay. Ms. Rivers, good morning. Happy Monday. Can you hear us?
Good morning, Judge. Yes, I can.
Great. Well, we're going to get started.
Can council pull the microphones in front of them, please?
Sure. And the should be a green light on the microphone.
Red lights, if I push the button by the red light, it should turn green.
Yeah, there's a little dip, and if you put your finger pad in there and then take it out, it should turn green. If you struggle with that, Deputy Gordon has warm hands, and so he'll make it work.
Okay,
You got it?
is that better?
Thank you.
Thank you.
Excellent.
I don't have a green light. It just went dark.
Is it red
Yes.
on that one? Okay, well, Ms. Rivers will let us know if we can't hear you, in which case you'll need to relocate either to the witness stand or wherever. But right now you're on screen so she can see you, which is good. And if the mics are picking up your voice, we're good to go.
Thank you, Judge.
You bet. So we're going to get on the record in State versus Gentle, which is on the trial calendar as a 24 SC indictment. It has been reaccused, and now the case number on which we're going forward, and we'll talk about dismissing the older numbers later. The case we're going forward on is 25 SC 006 573, which is an accusation that was just this morning numbered by the clerk's office. It was e-filed back on Friday, but it received its number now. And we're going to move forward on that matter, which charges one count of cruelty to children in the first degree. Ms. Williams, are you ready to proceed?
Yes, Your Honor, I am.
All right. And Ms. Fry, are you ready to go forward on behalf of Mr. Gentle?
We are.
All right. I am fine having you two stay seated there rather than be up at the podium. If you don't like that format, let me know. Otherwise, we'll just keep everyone seated at council table.
We can check for just a second because my client is 84 years old and has a hearing issue. So I just want to make sure he can hear and understand everything that's going on.
Well, I was about to ask him that, but I was asking you first. Are you okay staying at council table?
I'm more comfortable here.
Okay. Good morning, Mr. Gentle.
Good morning.
Are you able to hear what I'm saying when I'm talking?
Yes, sir.
Okay. If at any point during this morning's conversation, you cannot hear what the prosecutor says or someone else, let Ms. Fry know, and we'll make sure people lean into the microphone and really say it, okay? You will be the person doing much of the talking today, so make sure when you do speak, you speak up. I can hear you, and so if I can, I bet the court reporter can as well, but she's virtual, so she's picking everything up through the microphones, all right? All right. We're moving forward on an accusation, and it's my understanding, Ms. Fry, that in the docket of this new accusation, there is a waiver of indictment that you and your client discussed and that you and your client executed. Is that correct?
I executed it, Your Honor, with express permission.
Excellent. Okay, good. Then we are going to go forward. Mr. Gentle, in just a moment, Ms. Williams is going to put you under oath. Once you're under oath, you'll need to answer all of her questions and my questions truthfully and completely. If at any point during our conversation, you're confused about what someone said, you want to speak with Ms. Fry in confidence, anything like that, let me know. We'll take a break for as long as you and Ms. Fry need to break. Understood?
Yes, sir.
All right. Ms. Williams.
Thank you, Your Honor.
You need the plea colloquy, and this is an offer plea.
I'll be getting it from you when I get those signatures verified.
All right, thank you.
Yep.
And Your Honor, I think this is only the second time I've ever taken a plea in front of you. Do you want me to go by the paperwork that Mr. Gentle has signed or the plea colloquy I usually go with?
The latter.
Okay, thank you. Mr. Gentle, could you please raise your right hand? Do you affirm that the testimony you shall give in the matter currently before this court shall be the truth under penalty of perjury?
Yes.
Thank you, sir. You may lower your hand. Could you please say and spell for the record your full legal name?
Marvin Glenn Gentle.
Spelling.
MARVIN GLENGENTLE.
Thank you, sir. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Yes, no.
What is it?
It's a whole list.
So, Mr. Gentle, instead of having to rattle off all the medications, I'm gonna ask more of a summary question. Is there medication that you take in the morning?
Yes,
Did you take it this morning?
yes,
Is there any medication you were supposed to take that you did not take?
no, sir.
When you take the medication that you take in the morning, does it make you woozy or drowsy or disoriented? You feel like you understand what we're doing here this morning?
Yes,
Is there medicine that you take at night
yes,
before you go to bed?
yes,
Did you take that medicine last night?
yes,
Does any of that medicine leave you with residual effects in the morning where you are disoriented or woozy or confused?
no, sir.
Thank you.
Thank you, Judge.
You're welcome.
Ms. Fry, are you satisfied your client is able to proceed with this plea?
I am
Mr. Gentle, how old are you?
84,
How far have you gone in school?
I have a master's degree.
Are you therefore able to read, write, and understand the English language?
Yes,
Ms. Fry, on behalf of your client, do you waive formal reading of the indictment?
of the accusation. I think we need to put the language of the accusation on that
Understood.
due to the fact that we just filed it.
Then why don't you read count one into the record? It's in the record in the sense that it's in this new docket number, but if you've got it in front of you, if you just read the language of count one, that'll make it part of this transcript.
Thank you, Judge. Count one is cruelty to children causes excessive physical or mental pain, first degree, pursuant to the Official Code of Georgia annotated section 16-5-70. State of Georgia, County of Fulton, in the Superior Court of said county, on behalf of the people of the state of Georgia, the undersigned Fonnie T. Willis, District Attorney, as prosecuting attorney for the county and state aforesaid, does charge and accuse Marvin Gentle with the offense of cruelty to children, causes excessive physical or mental pain, first degree, OCGA section 16-5-70, felony, for the said accused in the county of Fulton and state of Georgia on the 15th day of May 2023. The accused maliciously caused Logan Walling, a child under 18 years, cruel or excessive mental pain by touching a part of the body of Logan Walling in an insulting and provoking manner, contrary to the laws of said state, the good order, peace, and dignity thereof. Fonnie T. Willis, District Attorney. Mr. Gentle, do you understand that you are charged with cruelty to children in the first degree?
yes, ma'am.
Sir, have you had an opportunity to review the rights that you are waiving or giving up by entering a plea of guilty?
Yes,
Have you had enough time to speak with your lawyer, Ms. Fry, and her team about all the facts and circumstances known to you regarding the charges in this accusation, including any potential defenses?
yes, ma'am.
Do you need more time to discuss the case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes,
Ms. Fry, on behalf of your client and for the purposes of this plea only, do you waive any and all defects in the indictment, including any with respect to his name?
Correct.
Thank you, ma'am. Mr. Gentle, have you been arrested on these charges?
these, Dr.
Well, the original, the set of allegations, I know that we have a new allegation in this accusation, but originally you were indicted for child molestation. Were you ever arrested in connection with those charges?
Yes, when they found me, yeah, yes, but
He spent 98 days in custody.
Okay.
Ms. Fry, the state is unaware of any outstanding warrants related to these charges. Do you know of any?
I do not.
Mr. Gentle, has your attorney advised you of the minimum and maximum sentence for each charge you are pleading to?
yes, ma'am.
And for the record, the minimum and maximum for cruelty to children in the first degree, minimum is 1 year, the maximum sentence is 20 years. Mr. Gentle, do you understand that this is a negotiated plea of guilty, which means that the state and your attorney will make a sentence recommendation to the court, but the court does not have to accept that recommendation. The court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other. Your Honor, and Mr. Gentle, the actual terms of the recommendation are as follows. For count one, cruelty to children in the first degree, the state and the defense recommend a sentence of 10 years probation with the following conditions. Condition number one, contact with minors and incidental contact with minors. You shall not have any contact with anyone under 18 years of age through any means of communication, in person or otherwise. You shall not go to any child care facility, elementary, middle, or high school, nor any area where minors congregate, as that term is defined in Official Code of Georgia Annotated, Section 42-1-12, Paragraph A, Subparagraph 3. Area where minors congregate shall include all public and private parks and recreation facilities, playgrounds, skating rinks, neighborhood centers, gymnasiums, school bus stops, public libraries, and public and community swimming pools. You may attend and participate in adult-only recreational cruises and resorts. You may go to senior centers for recreation, but you may not attend or participate in any programs or activities that include anyone under the age of 18. You shall not be employed nor volunteer in any position that requires direct contact or supervision of anyone under the age of 18. Any exceptions to this condition must be approved by the court or your community supervision officer in advance and in writing. You may attend gatherings and/or social events. However, if said gatherings include direct or indirect contact with anyone under the age of 18, you must either 1, get approval from the court or your community supervision officer in advance and in writing, or 2, an adult who has knowledge of your history of criminal sexual behavior and/or abusive behavior, who has been approved by your community supervision officer or deemed a chaperone, by your sex offender treatment provider, must be present at said event or gathering. If you attend a gathering or social event that has not been approved in advance, nor are you being supervised by an approved adult with knowledge of your offense history, and a person under the age of 18 is in attendance at said gathering, you must remove yourself as soon as reasonably possible and report the same to your community supervision officer within 24 hours of said contact. Prompt removal from the situation and reporting the same to your community supervision officer shall not constitute a violation of this special condition. Condition 2, residence with a minor. You shall not reside with any child under the age of 18, including your own children, unless approved in advance and in writing by the court. Special condition 3, residence change. You shall not change your residence without receiving prior approval by your community supervision officer. Special condition 4, visual media of minors depicting sexually explicit conduct. You shall not view or possess any visual medium as defined by Official Code of Georgia Annotated, Section 16-12-100 of a minor under the age of 18 years old, including film, photograph, negative, slide, magazine, or other visual medium depicting sexually explicit conduct as defined by Official Code of Georgia Annotated, Section 16-12-100. Special Condition 5, sexually oriented media and phone service. You may only have access to sexually explicit material, pornography, adult bookstores, adult movie houses, explicit media outlets, or any other adult entertainment businesses providing services or media that are sexually explicit in nature if your sex offender treatment provider, if applicable, or another provider licensed under Georgia law with specialized training in the assessment and treatment of sexual offenders finds that access to otherwise legal adult sexually explicit material does not create a risk to reoffend under the specific facts and circumstances of your case and or the current or past sexual offense treatment plan. Access to any sexually explicit material will be limited only to what the qualified professional deems appropriate in your particular case. If the qualified professional, based on their training and experience, finds that access to sexually explicit material would create a substantial risk to reoffend, such access shall be prohibited by this condition. This condition shall not be construed to prohibit you from possessing media, pictures, videos of your own body, so long as you are depicted alone. You may share pictures, videos, media of your own body for the purposes of medical treatment. You are prohibited from sharing any sexually explicit media with others, including of yourself, where such behavior creates a risk to reoffend, as determined by your treatment provider or other qualified professional as defined above. Any approval or opinion from your sex offender treatment provider or other qualified professional must be in writing and provided to your community supervision officer prior to any access to sexually explicit materials or the places outlined above. You shall be required to sign an appropriate release of information for your community supervision officer so that they may verify any reports with said treatment provider or qualified professional. Special condition 6, no contact with victim. You shall have no contact with the victim, Logan Walling, including correspondence, telephone contact, any form of electronic communication or communication through a third party, except under circumstances approved in advance and in writing by the court. You shall not enter onto the premises, travel past, or loiter near where the victim resides. Special condition 7, alcohol. You shall not purchase, possess, or consume alcoholic beverages. Special condition 8, you shall not take into your body any controlled substances or mind-altering drug except pursuant to a legal doctor's prescription. Special condition 9, drug screens. You shall submit to and if necessary pay for breath, urine, blood, or saliva tests for analysis for the possible presence of a prohibited drug or alcohol. And finally, special condition 10, travel. You may travel out of the state and internationally with at least 14 days notice to your community supervision officer. Mr. Gentle, having heard the terms of the recommendation, do you wish to proceed with this plea?
Yes, ma'am.
Sir, do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts? Are you currently on probation or parole? Sir, do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence? Do you understand that you are not allowed to possess or use a firearm while on probation? Are you a U.S. citizen? Are you a U.S. citizen?
Yes, ma'am.
Sir, do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, and or your right to receive, possess, or transport a firearm. Yes, sir. I can repeat the entire, that entire sentence. Do you understand, sir, that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote. This guilty plea may also affect your right to hold public office, your right to serve on a jury, your right to obtain a passport, and or your right to receive, possess, or transport a firearm. Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison? Sir, do you understand that you do have the right to plead not guilty?
Yeah.
Do you understand that if you plead not guilty or remain silent, this matter could proceed to trial? Do you understand that by entering a plea of guilty, you waive any and all defenses, including but not limited to any mental health defenses or any assertions of self-defense? Do you understand that by pleading guilty, you are giving up each of the following rights? I'm going to go over them individually. Do you understand that you are giving up the right to trial by jury? Do you understand that you are giving up the right to remain silent and not incriminate yourself? Do you understand that you are giving up the right to confront witnesses against you? Do you understand that you are giving up the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case? Do you understand that you are giving up the right to the presumption of innocence? Do you understand that you are giving up the right to testify on your own behalf and to present other evidence? Do you understand you are giving up the right to subpoena witnesses and compel the production of evidence? Do you understand that you are giving up the right to have the charges against you proved by the state beyond a reasonable doubt? And finally, do you understand that you are giving up the right to appeal if convicted of these charges after a trial? Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea? Is it your decision to waive these rights and enter a plea of guilty because you have decided that it is in your best interest to do so? Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial? Are you asking the court to accept your plea as guilty under offer? As to accusation number 25 SC 006573, how do you plead to the charge of cruelty to children in the first degree? As to accusation number 25 SC 006573, how do you plead to the charge of cruelty to children in the first degree?
Your Honor, we discussed this being an offer plea. Mr. Riddle is offering his guilty statement based on offer that in the best interest of the jury. And there's a factual basis for this.
Okay, that's what I understood was happening. Okay.
Thank you. Is this guilty under offered plea freely and voluntarily given with full knowledge of the charges against you? Have you had an opportunity to examine the accusation?
Yep.
Do you understand that you may have only a limited right to appeal this guilty under offered plea conviction? Do you understand that you have until the last day of the current term of court to file a motion to withdraw your guilty plea? Do you understand you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea? Do you understand that the appeals and petitions we've just discussed must be filed by your attorney unless you are representing yourself? Do you understand that unless your attorney is substituted or permitted to withdraw, your current attorney will represent you until either the end of the current term of court or 30 days from today's date, whichever is later? Mr. Gentle, that's all the questions and information I have for you, sir. I will now turn to providing a factual basis for the plea to the court. Your Honor, on May 16th, 2023, officers responded to the lobby of the Roswell Police Department regarding a child molestation report. Robert and Jessica Walling came to report that their 8-year-old son, Logan Walling, told them that his stepfather, Marvin Gentle, touched him inappropriately the previous day.
Stepfather or step-grandfather?
Step-grandfather, I apologize.
Okay.
Step-grandfather, Marvin Gentle, touched him inappropriately the previous day on May 15th, 2023. LW gave some details of the incident to his parents, but later participated in a forensic interview to give the details about the incident to interviewer Leslie, LES L-I-E, Deal, D-I-E-H-L. The child stated that on May 15th, 2023, he was at his grandmother's house, whose name is May, M-E-I, Gentle, G-E-N-T-L-E, with his step-grandfather when the child stated that Mr. Gentle made him do something illegal. The child stated that the illegal act was touching privates, which the child indicated to be the penis. The child stated he was at his grandmother's house with his grandmother and step-grandfather when his grandmother left to go to the store to get cupcakes for his sister's birthday. The child was alone with the defendant. The child asked the defendant if he wanted to play a game. Mr. Gentle suggested playing catch and told the child to target Mr. Gentle's private area. The child threw the ball and struck Mr. Gentle in the male genital area. Mr. Gentle then told the child it hurt and told the child to massage his private area. The child did so and stated that he touched him outside the clothes. The child stated this occurred another time. The child then stated that defendant also massaged the child's private area over his clothes. Your Honor, that concludes the factual basis for the plea. I can provide a criminal history summary.
I'll get that from Ms. Mann in a moment. She's on the call. But the child said that this situation of massaging outside the clothes happened on another day as well, or it just happened twice during this game that was suggested?
It happened twice during that game.
So the May 15th incident is the only incident that the child reported having had happened with his step-grandfather.
Yes, that is my understanding. And it is also my understanding that the victim and his family may be present on Zoom, if Your Honor would like to hear from them.
So they have a right to be heard from. I would, of course, like to hear from them. But if you want to speak with or communicate with a victim witness advocate to see if any family member does want to be heard, I'm interested in that. If they want to, they're not required to, no obligation to do that. But we should sort through that because I have a question for you if they're not going to be saying anything.
Yes, Judge. I'm communicating with the victim witness advocate at this time.
Okay. There's a Ms. Williams who's on the screen. Is that your victim advocate?
Yes, Judge.
Okay.
Yes,
Hey,
Your
Ms.
Honor.
Williams.
Hi, good morning, Your Honor. The mother and father is on, and the mother has a statement she would like to read.
Okay. Is that Jessica Walling?
Yes, sir.
All right, Ms. Walling, if you could turn, there you go. Let me get you on the screen. Good morning, Ms. Walling. How are you?
Morning, I'm okay.
So I'm Judge McBurney. I don't think we've met, but if there are things you want to share about how your son is doing, I'm particularly interested in that, but also your feelings about how this case is being resolved. Because that's what I was going to ask Ms. Williams about is, so what does the family say about what the state is recommending here? You don't have to comment on that. I'll get Ms. Williams' input if you don't want to comment on it. But I'm here to listen to whatever you want to share about this situation. And I appreciate you being here. I know this isn't what you want to be talking about or dealing with in your life, but here we are.
Yes, I have a statement I'd like to read.
Okay.
My name is Jessica Walling. I'm the mother of Logan, the victim in this case, and I make this statement on behalf of my husband, Robert Walling, and myself. I'm here today to give the court a sense of what this has done to our family and to our son's sense of safety and trust. I'll start by saying that this has ripped my family apart. I was utterly shocked when my son first told me that Mr. Gentle had molested him. I had considered Mr. Gentle, my mother's husband, a part of our family for almost 15 years. We spent holidays together, we went on vacations together, and he came to my children's soccer games. He was someone I respected and considered a grandfather figure to my children. My mother and Mr. Gentle were among the very few people I entrusted with my children. I've come to realize that I never truly knew the person I thought I did, especially as previous arrests have come to light. The betrayal of that trust has been devastating. It's hard to describe how disorienting it feels to realize that someone who was in your family photos, who hugged my children at holidays, was secretly violating that trust. My relationship with my mother has become rocky, complex, and confusing. Someone I've always been close with, I now keep at arm's length. I find myself questioning whether I can trust her judgment or feel comfortable leaving my children in her presence. I rely on my husband to coordinate with her for things like soccer games and barely want to speak to her. That loss of closeness has been painful in its own right. I also worry for her safety because she remains married to Mr. Gentle to this day, and I'm not sure she truly understands who he is or if she ever did. This has also created unnecessary disruption to our lives. The incident occurred on my daughter's 3rd birthday, a day that should have been one of the happiest for our family, now permanently scarred by this event. What should have been a day of joy and celebration is now forever marked by trauma. The uncertainty over the past 2 years has haunted me. The long stretches of silence, the waiting without knowing when or if anything would happen next, the sudden changes in the course of events. It was unbearable at times. It often felt like the pain just lingered in silence while our lives were on hold. I've struggled with anxiety, depression, and isolation. This isn't something you easily bring up with even your closest friends. It's a private pain you keep close to your heart. The emotional roller coaster has taken a serious toll on my mental health. I felt withdrawn and depressed and have sought therapy to cope. At times, it has felt impossible to focus on work or even simple family routines. I lost all interest in working, first right after the incident when I left for another company, and later as the case built over the summer and I watched the forensic interview. I stopped working completely in June. This created a financial burden, reducing our household income by about 50% and placing all the pressure on my husband, who became the sole provider. We had to make difficult choices, cutting back on activities for our children, postponing expenses, and living with constant stress of financial strain on top of emotional pain. But most importantly, the greatest impact has been on my son, Logan. A few months after the incident, his teacher called to tell me he had been unusually emotional and expressing feelings of worry and overwhelm. The stress on a child having to talk through a traumatic incident, not just once during the forensic interview, but repeatedly with us in therapy, and the feelings of embarrassment and confusion are unimaginable. Logan still struggles at times with sadness and self-doubt, questioning whether he did the right thing. He wonders if people are angry with him or if his father and I are worried or stressed. My selfless child, even in his pain, never once focuses on himself. His questions are always about the well-being of others, no matter the number of times we reassure him that he did the right thing, he continues to question. And I know that as he reaches puberty, he will revisit this trauma and begin to understand it in new and painful ways. The thought keeps me up at night. I'm proud of my son. Logan is strong and brave. Most importantly, I know that we have a close enough relationship and open dialogue that he can tell me anything that bothers him. He keeps no secrets from us, and unfortunately, that has been battle tested. I hope and wish that every child who has suffered abuse or molestation can have a relationship like ours. Someone to listen, defend, and fight for their justice. As the parents of an 8-year-old then, and now an 11-year-old, we did what we had to do, protect our child and ensure that justice was served. But is it enough? Is 10 years of probation enough? From a mother's heart, no, it isn't. No punishment can restore my son's innocence or undo the fear and confusion he has been forced to carry for the rest of his life. 10 years of probation feels deeply insufficient for what was stolen, the peace, the safety, the trust that every child deserves. Finally, I want to thank everyone from the Roswell Police Department, the Stephanie Blank Center for Safe and Healthy Children, and the Fulton County DA's office who helped us navigate this incredibly complex process. Their compassion and professionalism gave us the courage to keep going when it felt unbearable, especially ADA Christina Clark and her team. Ms. Clark and her team have been a light and an inspiration to our family. She took the time to communicate with us, explaining each step along the way. She truly puts victims at the forefront and made us feel seen, heard, and cared for. This is a thankless job, one where you witness far more than anyone should have to. And you are likely just as scarred as we are from seeing it every day. You are deeply appreciated, and your service is invaluable to children and families throughout this county.
Ms. Walling, can I ask you a few questions?
Sure.
First, thank you for sharing that. That gives me insight that I wouldn't have without you being here and providing that. Ms. Clark in the past, when she was working on the case, told me some about it, and obviously Ms. Williams has as well, but it's important to hear from family members who were directly affected and have seen, most importantly in my mind, the impact this has on Logan. How is he doing now in school? Is he doing well academically, socially? How would you describe? I know he's struggling. I didn't not listen to what you were saying, but I'm curious if there are also bright spots and he's plugged in at school, or how you would describe that.
He is plugged in at school. I think it's just the emotional, psychological pieces and he's embarrassed about it. So he tries to put on this happy face in front of everyone.
Sure. He seems to be very focused on how others are doing. And I hope you and therapy are giving him the time to focus on how he is doing. Does he have outside interests? Does he play a sport or an instrument, or what does he do when he's not a student?
He does. He likes to play soccer and he plays violin and chess.
Okay, good. You asked a powerful question, which is 10 years probation enough? And enough is a complicated word, and sentencing is a complicated process. I work with victim family members who say, I want the defendant to rot in prison for the rest of his life. I work with victim family members who say, what's the point in locking up this person and having another life trend in a direction that isn't healthy, et cetera? And they're in between answers. What do you think if you were handing down a sentence to Mr. Gentle, knowing what you know about him, his age, but also his background, what is it that you think none of this makes your son whole? We don't have that magic thing that we can shift the pain and suffering from the victim and the victim's family to the perpetrator. But I am curious to know what you think a reasonable sentence is, given all that you know about the situation and needing to move forward and maybe having your mother stay in your life, maybe not. I mean, you are negotiating some very complicated family dynamics right now.
I mean, I just don't know. I don't think that it's fair for someone to not spend any time behind bars for what was done.
Mhm.
And I don't think age gives you this wild card of freedom that you can do whatever you want to. And I don't think someone with dementia could come up with a game that he can devise with a lot of instructions to my child and tell my child to keep it a secret from me and his grandmother. That isn't dementia. That was a very, I don't know what the right word is, but that was a very, you had to put a lot of things together to get to that point, to be able to get a child to do that.
Sure, it sounds very sinister and manipulative, and knowing what you need to do to keep a kid quiet about something. So I hear you on that. Are you able to work again? Is it a two-income household again, or are you still not working?
I'm still not working.
Okay. Anything else, Ms. Walling, you want to share with me?
I think that's it.
Okay, well, like I said, I very much appreciate you participating in this discussion. I know it's not easy, but it's very important that I hear from both sides. I'm confident I'm going to hear a lot about Mr. Gentle, but it is good balance to also hear about the impact this situation has had, most importantly on Logan, but these collateral effects that you helped me understand as well. So thank you.
Thank you.
All right. Ms. Smith-Mann, good morning. Could you share with me, please, any criminal history information you have on Mr. Gentle?
Yes, Your Honor. Good morning. There are 5 prior arrests, not including the one before you today. 1191 DeKalb County PD, theft by shoplifting. First Offenders Act on 492. 1292 Cobb County Police Department, theft by shoplifting. Convicted 993. I have nothing further, Your Honor.
Okay, you said that, I thought you said there were, oh, those are the convictions, but there are a few other cycles. Got it.
Yes, Your Honor. There are
Okay.
cycles. Would you like to hear those other cycles? But those are the only convictions.
I'm curious if there are any cycles that involve any sex-related offenses. I understand they're cycles, so they're only arrests and they're not probative of much, but they are data points.
Okay. There is a stalking charge with 404 that was a no prost. There is a 2014 solicitation of sodomy, Your Honor, dismissed to 2015. Enticing a child for indecent purposes. Oh, that one is what was before you today, Your Honor. So please disregard that last one.
Got it. The stalking one was actually indicted, but ultimately no prost?
According to GCIC, it has, I'm going back up to it, Your Honor. Okay, 2004, Carroll County Sheriff Department, stalking, no prost on 5/6/2008.
All right. Thank you so much.
You're very welcome.
All right, Ms. Fry.
Yes, Your Mr. Federal, you have before you the report. It is not a start.
Ms. Fry, can you move in closer to the mic? Sorry.
I can hear you. The important part is Ms. Rivers.
Mr. Gentle is an 84-year-old honorably discharged veteran of the United States. If the court will call them, we mentioned during a complete colloquy that when Mr. Gentle was arrested in this case, he was held in custody in Rice Street for 98 days before he was given that bond. And
So he had no bond, and then we got to the 90th day or thereabouts, and a judge had to set a bond?
I'm not sure about that, but if it was set, that's the likely scenario that occurred. And there's been, I believe, 2 indictments in the case. As Ms. Clark was the assistant district attorney, Mr. Stay still has an income monitor on his leg, so he's had one since.
Okay.
And has been monitored. There's been no issues doing that. We're asking the court to accept the recommendation as the court calls this case has litigated pretty extensively in your courtroom of motions, as well as a separate trial this morning. And this case, through a change of Ms. Williams and a acknowledgement of the situation in the case, brought a different resolution before the board, which I think is a adequate resolution for both sides to avoid the risk of trial. Both Mr. Gentle's age, you caught a little bit of his hearing deficit as well. So let me explain a little bit about the dementia diagnosis. He has congestive heart failure. The court's been aware of that in the past. That's been part of this case. He also has a diagnosis of dementia. Well, I do think Mr. Gentle absolutely understands what's going on here today. A trial would have been exceedingly helpful from a hearing standpoint, and also to get him to understand testimony as it came out. As the court's aware, I'm aware, we know the trial, it's happened very quickly. People don't always speak up and use microphones. It's very difficult to make sure you're doing it there going on. That being said, that is Mr. right, which he is waiting today, accepting responsibility and accepting a probated sentence with the condition. The conditions that you heard Director Clay explains it. Mr. Grislow and I have been litigating these through the probation revocation. So there's some case law that makes these, why they're so specific is going to give both direction to the defendant and to probation, so that we're not back before the board for any of this. So that's what we're doing. I can appreciate Ms. Rawlings' situation that she's been through. I think a lot of times family don't understand what starts to roll when there is an allegation of abuse, how long that's going to take, and how that goes forward. That part of the piece that I think sometimes of letting everybody know how it goes forward. I do a lot of cases for what's been in trouble before for witnesses have these. We still only pursue that. Ms. Gentle, it's your guts and smallest mother. They are still here to this day. I think the court can understand and appreciate that there can be different interpretations of what occurs in a case, which led us to not only a opposite posture, but also the presidential posture today. So, as an officer of the court, I think this is the best resolution for this matter today, and I'm set. Negotiated resolution. Additionally, Judge, this is not part of the negotiation. Is it negotiated so that so that it's a registry offense, and it would not be a registrable offense. It's working the way it is, or that's our expectation now.
Okay, I figured that's why the conditions of probation were as detailed. Some of them seemed almost copied from registration requirements, saying, in effect, you will have some of the restrictions that you would if you had registered, but only for the duration of your probation. And you're not on the registry, which means you don't have to move.
And that was one of the biggest things, both Mr. Goodman's in law school. I don't know if it's the case in book review, but there's literally no housing that's in this directory. And I'm guessing it's saying needs to be brought. So that's all we contemplated today. As the work you saw with Ms. Williams and I on 30 days, we done as well. Continued through Friday with Ms. Hodge, and that's why we're here before the board today. So I think we've gone over all the issues that are involved in this case. We're asking for the credit for the 90 days that my comment has been made. I think I would go along. I would not think under the That's it.
Okay. Ms. Williams, why the no registry resolution? And that decision may have been made above your head, but I'm curious, given some of the concerns that Ms. Walling articulated, and I know Ms. Clark, your predecessor on the case, had articulated that the state shared with Ms. Walling. I'm curious if you could shed any light on what was behind the decision. I know a lot of the back and forth on Thursday was, well, what's the offense going to be? And does that trigger a registration requirement? And we even had a discussion, lawyers and I, about, well, maybe we take the plea today, but we delay an imposition of a sentence so that Mr. Gentle would have time to relocate. Because while I don't disagree with Ms. Fry that there aren't necessarily a lot of attractive addresses in Fulton or Cobb that comply with the registry, that's not true in all of Georgia. But here we are, and I'm just trying to understand a little bit of the state's thinking.
Your Honor, as you stated, of course, on Thursday, as I was speaking with Ms. Fry and Mr. Denslow, I did have more senior members of the district attorney's office to come in and assist me with this, which is my first case as an ADA in the Crimes Against Children unit.
Good one to land on.
Exactly, Your Honor, and it's before you, so I'm glad to be here. The registration was a sticking point in the negotiations. There was some discussion about a charge that would require registration, but that would have been a shorter amount of time on probation. So it's sort of perhaps not the best exchange, but a longer time on probation with similar restrictions.
Given Mr. Gentle's age and some of what's been described about his health condition, sounds like they're functionally equivalent. Mr. Gentle will be on probation long enough that should he still be alive, and we hope everyone lives a long life, he'd be coming up on 95 when he'd be coming off probation. And query, what's the point of having registry requirements for someone who's 95?
Correct, Your Honor.
Okay.
There was also some discussion of the age out requirements for various other scenarios that we had discussed.
Okay.
There are just record and also some tree issues that would be to the problem from students in space. They not obligated those to that was part of the structure and the decision making that went into the resolution of that.
Okay. Incidental contact. I want to make sure we're as clear as possible about how that's supposed to work for Mr. Gentle, because it will be a condition of his probation that he is to not attend gatherings where there'll be people under 18 there. But I just worked through the scenario when I hear conditions like that. Mr. Gentle goes to Chick-fil-A. And a lot of the people who work at Chick-fil-A are under 18. I don't think we list, and he wouldn't know when he walks into a Chick-fil-A. Is this a day where there's a 15-year-old working the cash register versus a 22-year-old? Does he have to leave the Chick-fil-A if it looks like, but he doesn't ask the age of the people working there? Or is that kind of commercial context excluded from the restrictions? It doesn't say, and I'm not trying to, you can't have language that covers every scenario, but I thought there was going to be language about incidental contact, and that's the header of that condition. Number one, contact with minors / incidental contact with minors, but then there really wasn't a discussion about incidental contact in that scenario. He's riding a MARTA bus. I doubt he's going to be riding a MARTA bus, but he's on the bus and it's just a bunch of old heads with him. And then 3 kids from Woodward Academy get on. And does he have to get off the bus, or is that incidental contact? I don't want there to be gray areas where he thinks, I'm in the middle of nowhere, but I better get off the bus, unless that's what was negotiated. So I don't know if there's a phrase we could add to condition 1 that would in fact address the incidental contact. There is that final paragraph that says if you attend a gathering or social event that hasn't been approved in advance, and maybe that's what the incidental was, but I'm not thinking about he is thinking hey, there's bingo tonight, I'm going to go there. And turns out there are kids there. It is, I'm navigating life and I walk into a CVS to pick up my prescription, and there is a parent with an 8-year-old kid also in the CVS minding their own business. That strikes me as something that wouldn't have to be reported, constitutes incidental contact, but I'm not negotiating things.
If I can get report with a little assistance, in the past, how, assuming we're or discuss, is that if a child institutes contact with the defendant in any commercial or something like that, that the defendant politely excuses themselves. It is their responsibility to politely excuse themselves. So say you get to the arbitrary on the bus analogy, and mom with the kids get on the bus, and one of the children saunter over and, hey, what are you holding there? He is moving something away from the child without causing harm, but just to move himself away from the child. I think that gives a little more direction in that regard, from this thing from how his behavior is. And also, in general, the kid's life, yes, no biological connection to the murder of that under 18 his life no longer involves constant contact with children. So I think from your standpoint of commercial interaction, which is good for like cameras and adults and things like that, is fine. But when a child institute,
Why don't the two of you, we don't need to do it right this instant, we'll wrap up this proceeding, but I will delay signing the final disposition until you all can craft some mutually agreeable language that is sort of that catch-all for what I thought incidental contact meant, where yes, it would be initiated by a minor, or Mr. Gentle is conducting life's business by, like I said, walking into a CVS. He doesn't need to run out of there because there happen to be kids. He can't interact with them. And should they interact with him, as Ms. Fry was saying, he needs to terminate that and sort of go about his business. And that's not an artful way of saying it, but I would like it to, that little language to be in there, so it's not a repeat instant. He's calling his probation officer every day. Hey, I went to Starbucks and I don't know how old the barista was. You know what? If all you're doing is saying, give me this coffee, or I want a Big Mac at McDonald's, you don't need to worry about it. But if it's, you want to come outside with me and share my Big Mac, that's a problem.
Understood, Your Honor.
Okay. There are references in these conditions to sex offender treatment providers, but there's no requirement that Mr. Gentle receive sex offender treatment. Is the state thinking maybe he'll do it, and if he does, that's great? Or was there a condition omitted here? I doubt there was anything intentionally omitted, but it just confused me that there were references throughout that it's okay if the sex offender treatment provider says it's okay. But I don't get the sense that if Mr. Gentle never ever received sex offender treatment, he would be in violation of any of these conditions. He just wouldn't have a chaperone that a sex offender treatment provider had deemed appropriate.
because it was not negotiated in the conditions when the charge was changed. And I think, like, the nature of the charge being changed, we're trying to be as careful as possible. Again, it's not like this criminal registry requirement, but I think why this is so explicit, that if the situation changes, where they want to be in contact with minors in the same institution, then he would need to have a treatment provider okay that, full solution to that. and these are, again, language was specific, if they're constitutionally and rationally related to the underlying.
Okay. All right. The no alcohol. Do you have any information, Ms. Williams, that Mr. Gentle's consumption of alcohol contributed in any way to the offense conduct here?
Yes, Judge. Upon speaking with the family of the victim, they felt that potentially Mr. Gentle had consumed alcohol on the day in question, and that may have contributed to the situation.
Okay, and it was negotiated. The no prescription, no illegal drugs absent a prescription, I think always makes sense. The alcohol can be a unnecessary tripwire if someone has a glass of wine from time to time, unless there's a link. And it was in there, so I assume there was a back and forth, and Mr. Gentle's legal team didn't object so vociferously that it had to come out. So as long as that wasn't just well, we always put that in there, I'll leave it in.
It's negotiated.
Okay, I'll leave it in. Well, we'll get to that. So Ms. Simpson, my question was, do you understand it now? It's sort of like you ultimately would self-report. You get a letter or a call saying it's time, and then you go there, as opposed to you're stuck waiting. And you've helped me understand the waiting part.
Yeah, that part. Because this really problem that is submitted.
Okay. Can you make a call? Thanks.
Wait, is this involved in our case?
It is involving your case.
Oh, I don't know.
You don't, there's nothing for you to understand at this point. All will become clear after I get this additional information. That's Ms. Simpson, who is with the Department of Community Supervision. So she's going to be part of the conversation of any sentence that I hand down if we go forward with this plea. All right, well, I can march through some of this now before I hear what Ms. Simpson learns. Mr. Gentle, I've heard from your lawyer. I also can hear from you if there's anything you want to add. You don't have to say anything at all, but you have a right, just like there was a right of the Walling family to be heard. This is actually your plea, not theirs. So you have an equal right if there's something you want to say, but there's no obligation. It can all flow through Ms. Fry. That's up to you.
Yes, I'm still on. Oh,
You are.
okay. I don't like to use the word never, but just case I have never.
You sure can. Yep, you guys can confer, and hold on one second before you do that. Let me Okay, we are back on the record in State versus Gentle. Mr. Gentle and his lawyer, Ms. Fry, had a conference outside the courtroom. Mr. Gentle, you were in the midst of saying something and then your lawyer grabbed you. You all have conferred, but again, the floor is yours to share with me and everyone who is listening and watching whatever you want to about this situation.
I just wanted to say that I am very, very sorry, truthfully, very, very sorry for any anguish that it's caused Logan family, the anguish that it's caused my family. And I hope we all can go and pull out of this and carry on our normal human life.
Okay, thank you. So, Mr. Gentle, I find there is a factual basis for your plea. I know it's an offered plea, which is when a defendant says it didn't happen the way the state says it happened, but I agree that the state does have some evidence and that a jury could find, if the jury credited what Logan had to say and discredited other evidence, a jury could find you guilty of, I think, what was in the original indictment, but more importantly, what's in this accusation. But that you have decided, after consulting with your legal team, that it's in your best interest to go forward with a plea to this accusation. Do you agree with that? Okay. I find that your plea is knowing and voluntary. Knowing means you've understood the things we talked about, and if you didn't, you asked your lawyer about them. Do you feel like you have any questions at this point about anything we've discussed? Okay, I know we've got one variable out there in the sense that your lawyer and Ms. Williams are going to craft some language that addresses incidental contact, my Chick-fil-A example. And that's not a stumbling block. The language is out there and it may now be on a yellow piece of paper, but we'll get it woven into the conditions of your probation. I also find that your plea is voluntary, meaning that no one has forced you to enter this offered plea. Do you agree with that? Mr. Gentle, somewhere on that desk in front of you is a plea statement that involves a bunch of lines where you initialed, I understand my rights, and then I'm waiving those rights. Ms. Fry and you discussed it. I think it listed the maximum you could get and the state's recommendation. Did you have an opportunity to discuss that form with Ms. Fry? And did you sign that form? Yes. Ms. Fry, did you sign it as well?
I did, Your Honor.
Okay, we'll get that from you before you leave. There is an accusation in this case now. That's the 25 SC document. Ms. Fry, is it all right if someone from my chambers signs your name to that accusation for this offered plea?
Yes.
Ms. Williams, can we sign for you?
Yes.
And Mr. Gentle, can we electronically sign your name to accusation 25 SC 006573, indicating your offered plea to that case?
Yes.
We'll do that. And Ms. Fry, you filed on your client's behalf, well, I don't know who filed it, but you signed and executed a waiver of indictment so that we could move forward with this accusation.
That is correct, Your Honor.
All right. Ms. Williams, there is active and open in the docket still indictment 24 SC 005809, as well as superseding indictment 24 SC 005809-01. Assuming this plea goes forward, will the state be null processing or dismissing both those indictments?
Yes, Your Honor.
So you're all right if my office takes care of closing those out?
That would be wonderful. Thank you.
All right, we'll do that.
Thank you for remembering me too, Judge.
There are two, and they will both be null processed. Mr. Gentle, this has been a long journey for you, I know. For the Walling family, I am certain of, and Jessica Walling helped me better understand the impact that this situation has had on her household, on your household, and most of all, the person I'm most concerned about, on Logan. I was reassured to hear that he continues to show the type of resilience that I sensed when I watched the forensic interview, and that he's playing soccer and chess and violin. But that doesn't mean he's healed, and it doesn't mean that he doesn't carry with him the emotional scars that this situation will carry for him. I thought his mom was very astute in flagging a crossroads that he faces soon, which is when puberty arrives and he starts thinking about things in a different way. I suspect he will look back on what happened on May 15th, 2023 in an entirely different way, and one that could trouble him even more. But magically, his focus has been on, how's my mom doing? How's my dad doing? How's my grandmother doing? He's a very emotionally intelligent young man. I hope that he does spend time focusing on his own healing needs as well. I am not ever, and it's appropriate, part of the negotiations that are involved in resolving these cases. I know that at one point the state was recommending many years in prison for you as a result of what they understood this case to be about. Cases evolve, prosecutors change, supervisors get involved. They look at a situation and say, are we trial ready? Are we not? I'm not sure I am dialed into the evidentiary difficulties that Ms. Fry was talking to. I don't need to be, because I'm not the one trying the case. But I am aware of what a jury does if a young man comes in and testifies credibly, and his statements to friends and family members corroborate that testimony, and his forensic interview corroborates that testimony. It tends not to end real well for the person accused, just given the nature of the crimes. Your lawyers have an uphill battle because of the word molestation, regardless of what happened in May of 2023. Mr. Gentle, given what I've learned about you, about this case, about the Walling family, I am going to sentence you as follows. There is only one count. And I am sentencing you in this case to 10 years to serve 3 months in custody. Those 3 months you've already served. The balance will be on probation. It will be a condition of your probation that you spend 3 months in the probation detention center. You will then be subject to all of the conditions that were set forth in the negotiated conditions. I am adding one, and that is that you will in fact participate in sex offender treatment. You'll be required to enroll in that treatment. I don't know if enroll is the right verb, but begin that treatment within 3 months. And you will need to receive sex offender treatment for at least a year, or until the treatment provider says it's not necessary. If that's only 2 months, you only have sex offender treatment for 2 months. I'm not the subject matter expert there. One caveat to that, I do not intend you to have to register as a sex offender. Your lawyer negotiated that. The state changed the charge. This is not an offense that ought to require registration. I don't believe, as a matter of law, that my addition of this condition would trigger registration requirements. But if for some reason you're approached by the authorities, say now you need to register, then you should let Ms. Fry know that. She will let me know that. And I will modify, well, one, I'll engage with those authorities to say, what are we doing here? But if they present me with law, statutory or case law that said, look, you impose sex offender treatment, now we must make Mr. Gentle register, then I will remove that condition. But I don't think it will trigger that. And we're going to go forward in that way. You need to go back into custody in order to do the 3 months at the probation detention center. That's not today. You are not going into custody today. Ms. Fry is going to talk to you about a reasonable reporting date, and she's going to let me know when you can report. I'm assuming, Ms. Simpson, that would basically be reporting here because Mr. Gentle needs to be in custody to go to the probation detention center. Okay.
That wasn't a negotiation.
I understand that, and I wasn't part of the negotiations. We're past final plea. We are here today, and Mr. Gentle has indicated that he's going forward with his plea. I'm not bound by any of the terms. I could sentence Mr. Gentle to 10 years to serve. I'm not doing that. I don't think that that's a reasonable sentence in light of what I've heard. I don't believe that no additional custodial time is reasonable in light of everything I've learned. So I appreciate what you negotiated. I appreciate what Ms. Williams negotiated. I'm not part of that. It's not a tripartite negotiation. It never is. That's not legal. So I've heard all that. And I've explained that the sentence that I believe is reasonable, having learned everything I did, is what I just described. So,
And Your Honor, if I'm not familiar with your probation, there is a invitation that is really going on along with the universal. That I don't know how that is. It's one of those things. They go in without her medication, they're not giving them medication. Custody facility terms that they use sometimes can be days.
so I'm not interested in having Mr. Gentle not get the medication he's supposed to have. It's another reason why he's not going into custody today, because we'll need to navigate those things. And it may turn out that the probation detention center says, we can't take Mr. Gentle because of his documented medical condition. And if that is their professional opinion, then we actually do have an impact of age. I understand what Ms. Walling said. Jail and custodial locations are not the sole province of healthy young men. They are there for women. They are there for white people and black people and tall people and short people and old people, but not if it is not medically viable. And so this is not a death sentence. That's not what we're talking about. And if the healthcare professionals who operate the detention center look at Mr. Gentle's situation and say, we can't support that, then that's not what we're doing. And I'm not the one who would arbitrate that. If they say no, the answer is no. If they say yes, then I just need to see the reassurances that Mr. Gentle shows up with his medication, he keeps his medication, and we move forward that way. So I'm mindful of your concern and seek to accommodate it, which is why he is not having to fulfill that part of his probation. He'll leave here today on probation. He's going to get reporting instructions from Ms. Simpson. We will work out when do you report for the probation detention center. And the question I had for Ms. Simpson that you said you were confused about or you didn't understand was simply, could he report directly to the probation detention center? Like in the federal system, if a judge decides someone can stay out on bond until they start their custodial sentence, they actually get a letter from the Bureau of Prisons saying, you need to be in Kentucky on this day. That's not how it works with the probation detention center. It would be reporting here to this courtroom to go into local custody and then on to the probation detention center. But we'll build that glide path based on the different variables that we discussed. One of them is getting together that docket of medical care that Mr. Gentle is receiving, both pharmaceutical and the treatment he's getting. He's not on dialysis, but that's another example that we get sometimes. Look, this person's on dialysis. Some sentences don't work for people who are on dialysis.
Can I have a little bit of clarification on the sex offender treatment for a year until the providers say you do not need it? So if you ask the question about a psychosexual, if he has a psychosexual, it's not determined that he needs treatment, is that sufficient? Because I think the concern is you can't just go sign up for sexual offender treatment.
You're right. And that's how I should have phrased it, is that it's as it is with, for example, if there was a concern Mr. Gentle had a drug addiction. That's not my concern. It would be that he have a substance abuse evaluation and follow any treatment as recommended. And so you phrased it much better. And so within 3 months of your completion of the detention portion of your sentence, you will need to submit to a psychosexual evaluation. If that evaluation results in the recommendation of treatment, that treatment becomes part of your probation. And it lasts as long as the Professionals say it needs to last. That is a much better way to structure it. And so the evaluation may say this isn't someone who would benefit from that type of treatment, and not interested in wasting your time, or more importantly, the treatment time, when they could be focused on someone who would benefit from the treatment. The conditions that were negotiated are unchanged, with the exception that we'll be adding that language about incidental contact that the lawyers are working through. And what I'm going to do is ask that we reconvene, and this can be by Zoom. People don't need to be in court. And really, it's up to you, Ms. Fry, whether Mr. Gentle even plugs in, because it's basically in 2 weeks, we're going to have a status conference about what have we learned about how we connect Mr. Gentle's medical information with DCS, so they can determine is he someone who can go to the probation detention center. This doesn't delay the imposition of the sentence or the start of probation. We're able to be underway with the rest of all of that. Okay.
I'm sorry, I didn't hear that wrong.
She was asking that Mr. Gentle appear in person. Is there a packet that he could leave with today that they could be filling out, or he fills it out with your help? Okay, well, could we just email it to Ms. Fry so she's got it? Okay, so we'll email that to Ms. Fry. They can have it filled out before our status conference. I just want to have a check-in so we can talk about logistics. Is this something that works? And if so, then when is Mr. Gentle going to report? So you would get, if Ms. Fry and her client fill out that informational packet, then she can get it back to Ms. Nelson and it gets to you. Does that work? Okay. All right. So it's a two-step. We'll get that paperwork out. Okay. And Ms. Nelson will work, Ms. Fry, with your team and Ms. Williams to figure out a time in a couple weeks where we can hop on a Zoom call to talk about those logistics.
I think that's, and the sooner we get the packet, the better we're able to get to that medical information.
You'll get it today. Zoom date. All right, Ms. Williams, anything else from the state?
No, Your Honor, thank you very much.
All right.
Will we get a copy of this minutes today?
You will get it as soon as I sign it. It has a whole lot of language in it, and fortunately, it's already typed out, but Ms. Nelson is figuring out how to incorporate all that in there. But of course, we can't finalize it until you guys get us that proposed incidental contact language.
I will come that as soon as you said that, and I think that I sent that to Ms. Williams and updated one.
We're exchanging emails just to make sure.
Good. Once there is a mutually agreed upon, or hey, we agree on everything but these 3 words, I'll resolve the 3 words, whatever it is. Get that proposed language to Ms. Nelson, and then we'll have all the pieces to complete the final disposition. And once it's complete, I'll sign it, it'll get docketed, and you'll all have it.
There's just so this is on the record, that reading all at once. I think what we're talking about is regarding contact with minors in commercial settings, restaurants, stores, and public settings such as public transportation, government buildings, only to the extent that such settings are not within the category defined as places where minors congregate, libraries, etc., under the code section. If while in commercial settings and or public settings, the child initiates contact with the defendant is to excuse himself and promptly remove himself from such contact. The defendant may enter commercial settings and public settings, and only such settings are not within that defined category. But he is he is not to initiate or continue contact with minors. He must promptly remove himself from the setting as soon as possible. And we've sent you that, Ms. Williams, I think you're gonna see that.
Okay, no, that's very much along the lines of what I was thinking of. It means you can go into Jack in the Box and order a burger and leave, even if they're over in the corner, there's a family eating a meal. Bad idea to go into Main Event, which is just a place where kids play video games and bounce on trampolines and things like that. So I think that'll address it. You bet. Ms. Simpson, can you please give Mr. Gentle his reporting instructions? What's your zip code?
Your zip code 3075.
3075.
What county is that?
Boom.
That's your first 30075? We don't get a lot of defendants from.
Yeah, that is my first three, so. And so, Ms. Pryor, Mr. Jones' reporting date will be October 29th.
To probation detention if he is on.
No.
He is reporting to the Atlanta office, just to the probation office.
Okay. No, 9 days from today.
And that's simply reporting to their office to begin your probation sentence. It's not going into custody. It's just to get signed up with probation, meet your probation officer, and then you'll be subject to all the conditions that we've been talking about.
And is that at 9 a.m.?
That is going to be at
8 a.m. And there's the issue of why I was asking about the sentence is, Mr. Jones had a ankle monitor for almost 2 years, for over 2 years. His sentence is what fix that for me.
It is indeed. And so we're not holding it up for any reason. Once we get that language, which it sounds like it's on its way, we'll work on it. So I would be surprised if it's not e-filed this afternoon. All right, Mr. Gentle, do not miss your reporting date for probation on October 29th. That's the start of that relationship. If for some reason something comes up, you take ill, you can't be there, call Ms. Fry so that she can run interference for you and call probation saying, he will be there, here's a doctor's note, whatever it is. But they're going to expect you to be there 8 a.m. So that they can get you signed up for probation, okay?
Where is it?
It's about 2 blocks from here, but your lawyer is going to give you the address. It's on Memorial Drive near here. Okay? All right. Thank you, everyone.
Thank you, Your Honor.
Do you need this plea paperwork for the?
I do. Yep. If you'll give it to Ms. Simpson, she can bring it to me when she walks by.